Thanks to the Vermont Humanities Council. I've been giving talks for you guys for quite a while, and I'm only sorry not to be able to be in the Athenaeum in person because it's such a beautiful space, and I have had the opportunity to speak there a couple of times. So welcome to everyone. I can't honestly think of a more apt moment to be speaking about the legacy of Ruth Bader Ginsburg. So I would like to do a couple of things. Just first, open up with a brief slideshow to evoke her presence and her image. Then what I'm going to do is talk a little bit about her life story and her influences, and then turn to some of her major cases. And I'd like to close with her critique of the way, not the content of Roe v. Wade, but her fear that it was on shaky ground, and in some ways a prescient fear that it would be overturned based on some of the reasoning that we heard yesterday during the coverage of the leaked decision by Justice Samuel Alito. So for starters, let me share my screen and have a little bit of a moment with Ruth. So just to evoke her intensity. I like starting with this picture because it really does give a sense of how fully possessed she was by her work throughout her life. Here she is with her husband, Martin Ginsberg, who she married while she was still an undergraduate, who she nursed through cancer, as well as raising a child while she was in Harvard Law and then Columbia Law, where she followed him. Here's her image in law school at a moment when at Harvard Law, she was told that she was taking up the place that could go to a man, even though she was one of 8 female students in a class of 500. I really like this picture of her too. After she graduated from Columbia Law, which she found, Columbia University Law School, which she found a little bit more friendly to women. She graduated first in her class from one of the top law schools in the country. At Harvard, she was the first woman to be elected to the Harvard Law Review, but she could not get a job in the 1950s and 60s with a law firm. They simply would not hire a woman. And so she turned to the academic path. She taught at Rutgers Law School at first, and then she became the first tenured woman on the faculty of Columbia University Law School, where she got her degree. And I just like you can see from the expression on her students' faces, how adored she was, and you can only imagine what witty things she was saying. Here she is at home with her son, but he is, not surprisingly, watching her work, which apparently she did pretty much all the time. Here we have her at the ACLU Women's Rights Project, which I will talk about a little bit. It was the jumping off point for the 6 cases that she argued in front of the Supreme Court, and for her victories in litigating sex as an important category of scrutiny under the law. That made Bill Clinton, when he announced his decision to try to appoint her to the Supreme Court in 1993, he called her the Thurgood Marshall of women's rights. Thurgood Marshall, of course, was the first African-American justice on the court, and he had been the head of the NAACP Legal Defense Fund and a pioneer in overturning racial discrimination under the law. I don't think we all really knew that much about Ruth Bader Ginsburg back in 93, but her qualifications were enough to get her a 96-3 vote in the Senate, something that is unimaginable in this day. And I'll talk a little bit about her confirmation, bringing her grandchildren to the court. And finally, we have her here with her husband, Martin. It remained one of the great love affairs throughout her life. And he was incredibly supportive and proud of her. And as he liked to say, played a very essential role, which was reminding her that even she had to sometimes sleep and eat, something she would often forget to do. This is the Ruth Bader Ginsburg we've all known from recent years in her time on the court, and wearing one of her famous dissent collars because she sat on the court during many years of conservative majority. She was often ruling in dissent, writing in dissent, scathing dissents, and it was actually her dissents that made her famous. She collected a series of collars that she would wear when she was about to issue one scathing dissent after another. And those dissents made her, they made her kind of a rock star, the first Supreme Court justice to really be one. The Notorious RBG, based on riffing on a rap star, the Notorious BIG. So we have Supreme Court justice as meme. Here we are with her little crown, one of her dissent collars, justice as rock star. She became, someone who was on mugs, T-shirts, all kinds of cartoons. There's any number of posters and portraits of the Notorious RBG. And here we have some moments of mourning, spontaneous mourning, when she passed away at the age of 87 of the pancreatic cancer that she had battled for, I think, almost 9 years, which in itself burnished her credentials as a superhero, because pancreatic cancer is a very devastating diagnosis, which often takes people in a matter of months. And the date of her death in September of 2020, the country burst out in spontaneous street marches, combination of mourning and protest. You see here, RBG, we won't let you down. And also there were spontaneous memorials to her all across the country with her dissent collar. We will fight to protect, that sign says, we will fight to protect the rights you helped us get. And some of the kinds of iconography that emerged in the last years of her life. So let me talk about RBG now, and I'd like to just give you a sense of where she grew up and what her origins were. She was the daughter of a union garment worker, and she grew up in Brooklyn in the 1930s and 40s, at a time when people were arriving after the Holocaust. The news of what had happened in Europe was breaking. It was also a period when labor unions were extremely strong in Brooklyn. Jewish garment union activists, the International Ladies Garment Workers Union, the Amalgamated Clothing Workers Union. Her mother, the union garment worker, was a tremendous influence on Ginsburg, and she talked a lot about how her mother made her see two things. Her mother, who died when Ginsburg was quite young, left her, she said, with the legacy that women have to support themselves, they have to be fierce in the fight for their independence, and they have to stand together with others in order to achieve what they need to achieve. So that's, I think, the first influence that I want to give you is the influence of the milieu, both her mother, but also the milieu in which she was raised. She attended Brooklyn Public Schools, Madison High School, which was also attended by Bernie Sanders. And, both of them were shaped by the same milieu. And I only regret, I had a letter into the court some years back before she died, in which I wanted to have a discussion with her about that milieu and the way in which it shaped her and Bernie, and never got to do it, never forged ahead on it, but she was actually interested in talking about that. So she went to Cornell and was married, as I mentioned, before she got her BA, married the love of her life, Martin Ginsburg, who she would stay with till he died a few years before she did. And when she was accepted to Harvard Law, where he was as well, he was a strong supporter, but the environment was extremely hostile. And in particular, the dean that said to her, that called her on the carpet for taking the place of a man, was not mollified when she was appointed to the law review and began to write some of her early brilliant statements. So she was only too happy to return to New York City when her husband Martin was hired at Columbia Law. She finished her degree there, as I mentioned, first in her class, went out into the world, encountered the kinds of discrimination that women did in the legal profession in those days, even the most brilliant, right? Even someone who had already accumulated quite sterling credentials. And if you have seen both the documentary and the feature film about her, they chronicle her trudging through the streets of New York, to one law firm after another, attempting to find work. And when she didn't, she took the academic route. And from the beginning, she was very excited about the possibility of teaching because she wanted to make change through the law. She recognized that there was a great deal of discrimination under the law, and in particular, she was influenced by two legal scholars who would show up in one of her first famous arguments before the Supreme Court. One was Dorothy Kenyon, who was an attorney for the New York Women's Trade Union League, which was a cross-class organization of women dating back to the early 20th century that stood for the rights of and helped to support working women who were organizing into trade unions. So Dorothy Kenyon and her legal practice and the work she did supporting women workers in the labor movement was really influential to Ginsberg. And then her next influence was a brilliant mixed race scholar by the name of Pauli Murray. And Pauli Murray had written what Thurgood Marshall, then at the NAACP Legal Defense Fund, called the Bible of the Civil Rights Movement. She chronicled every single law on the books that discriminated on the basis of race to help the NAACP Legal Defense Fund develop strategies so that they could begin to litigate an end to Jim Crow. Murray was with Betty Friedan and a number of others, one of the founders of the National Organization for Women. And just the year before the National Organization for Women was founded as an intentional women's version of the NAACP, Pauli Murray wrote an article with her colleague Catherine Eastwood about Jane Crow. And she coined that term to talk about laws that discriminated on the basis of sex. And she didn't do anything as encyclopedic as the book that she wrote about laws that discriminated on the basis of race, but she made a really interesting argument, and it caught the attention of the young Ginsberg. And the argument was that in her view, there had been an equal rights amendment coming before Congress every year since the 20s. And there was a lot of question about whether or not the Equal Rights Amendment would get rid of any kind of laws that protected women in one way or another, or in any way treated men and women differently. And so that law, the ERA had never been ratified. And in fact, it never passed Congress until the 70s. And so Murray had a different suggestion. Murray argued that all of the rights that women needed to become equal under the law were contained in two amendments to the Constitution. The Fifth Amendment, which guaranteed the right to due process, and also to equal treatment, and the 14th Amendment's guarantee of equal treatment under the law, and also privacy. Ginsburg really was influenced by Murray's argument that that women could gain their rights by appealing to the Fifth and 14th Amendments in the cases that they raised. And so while Ginsburg was still teaching at Rutgers, she began to argue cases for the American Civil Liberties Union. And in 1971, she argued the first case that she would successfully argue before the court, and one that would begin to change the way sex was treated under the law. And that was the case of Reed v. Reed. And the Reeds were a couple in Idaho who tragically lost their 16-year-old son. And as sometimes happens, grief broke up their marriage. And they decided that they each, again, I think out of grief, wanted to become executor of their deceased 16-year-old son's estate. Now, the son did not have very much. I think it was really about, each wanting to have some feeling of being closer to him. Idaho had a law dating back to the 19th century, which said that if there is any kind of battle between a man and a woman, between a husband and a wife, over who should be executor of the estate, that it automatically should go to the man, because that's just, it was in the interest of the state. Men were more rational, blah, blah, blah. The law, had never been really challenged. And so what was interesting in arguing Reed v. Reed before the Supreme Court for the American Civil Liberties Union, Ginsburg argued very effectively. She was known for arguing in front of the Supreme Court without notes. She was known for having a mesmerizing speaking style. In the 6 cases that she argued before the court, 5 of which she won, the word mesmerizing appears in many of the descriptions penned by people who were in the room and listened to her speak. Anyway, she was able to get the court to decide, and William Brennan wrote that he was convinced by her argument that this was a violation of the 14th Amendment's guarantee of equal treatment under the law. And so what she began to get in this case was a validation of Pauli Murray's arguments. And Murray and Dorothy Kenyon were so influential in her ideas argued in Reed v. Reed in 1971 that she actually signed their names to the legal brief that she wrote, because she called it the grandmother brief, because she was really very aware of whose shoulder she stood on, to use a term that my students use a lot about activists today, right? They want to know whose shoulders they stand on. She wanted to make clear she stood on the shoulders of Murray and Kenyon, that was how she operated throughout her career, was in this cooperative way that she had learned from her mother. So in the next year, she pitched to the ACLU the idea of starting a women's rights project. So it's 1972. The feminist movement of those years was very coming up at full speed. Since 1966, the National Organization for Women had been challenging laws that discriminated against women. They challenged sex-segregated want ads in the newspapers, as a violation of women's right to equal protection. So suddenly the 14th Amendment was alive and well. Now, the 14th Amendment, of course, was passed after the Civil War. It was the first amendment after the 13th ending slavery. It was passed in 1867. So it has been the holy grail of civil rights law in the United States since that time. And that's why I think it's doubly important that we talk about it today, because it was cited in Alito's draft decision that was leaked yesterday. So I hope in the questions that we will talk a little bit about the 14th Amendment. So the ACLU went for the idea, and Ginsburg established the ACLU Women's Rights Project. And in 1973, she argued another case in front of the Supreme Court, Frontiero versus Richardson. And Frontiero versus Richardson was really interesting because it started this habit that Ginsburg had. She decided that strategically she would have more success if she argued cases of sex discrimination for male appellants. And that's what she did with her next couple of cases. And several of them were responsible for sex becoming a category of scrutiny under the law. So Frontiero v. Richardson was a case of a lieutenant in the Air Force. And the lieutenant was a woman, and the lieutenant wanted a dependent allowance for her husband, as male officers got for their wives. And the Air Force refused to do it because they said if the military started, they wanted proof that that Frontiero's husband was dependent on her financially, and Ginsburg argued that that was discriminatory because when male officers got dependent allowances for their wives, they were never asked to show proof. And the military lawyers responded, well, that's because most people in the military are male and we would be busy all day long going through documents. And also it's more characteristic for women to be economically dependent on their husbands. In the end, this time, instead of the 14th Amendment, Ginsburg argued that this violated Sharon Frontiero's right to due process under the Fifth Amendment. Right, the Fifth Amendment is the amendment that has habeas corpus. You can't be imprisoned for too long without charges being filed. The overall idea behind the Fifth Amendment is that everybody is entitled to the same legal processes. And Frontiero didn't get it. So Ginsburg won that case as well. And she wanted strict scrutiny under the law, which is what Thurgood Marshall had been able to establish race as a category of strict scrutiny under the law. Brennan, the most liberal of the justices, sided with her on that argument. But in the end, he lost by one vote. It was a 5-4 decision that sex would become a category of intermediate scrutiny under the law. So sex is still not treated in the same way as race to this day, but the fact that sex is a category to be considered under the law when decisions are made is a result of that case and the work of Ruth Bader Ginsburg. So here's a couple of interesting cases in 1974 and 1975 that she argued before the court. And again, it was her strategy of arguing for male appellants. In the Frontiero case, she argued for a female appellant, but she was arguing for benefits for her husband. In the next two cases, Kahn v. Shevin in 74 and Weinberger v. Weisenfeld in 75, she argued for men who were seeking their wives' Social Security benefits. Now, the rules had said that if one spouse had a higher salary, and that spouse died, that the surviving spouse could get the Social Security benefits of the spouse who earned more. That had almost always been applied to widows, and who were easily able to get access to their husband's Social Security benefits, which were greater than their own. In this case, the first case was, sorry. This, before we get to Social Security, in Kahn v. Shevin, this was a property tax exemption that Florida gave to widows, but not to widowers. It was just a $500 property tax exemption, and a widower named Mel Kahn came to the ACLU to say he deserved this exemption. So she argued this case for a male appellant and won, right? That the court ruled it unconstitutional that Florida would give the property tax exemption to widows, but not to widowers. So there's one case. The next two cases in 75 and 77, Weinberger v. Weisenfeld and Califano v. Goldfarb, were cases of men being denied their wife's Social Security. And interestingly, in the first case, the wife had been a teacher, and she had always been the primary earner in the house. She died in childbirth, and the widower sought her Social Security benefits and pension benefits to help raise his child. The lower court ruled that the child could get her benefits, but he couldn't. Ginsberg represented him for the ACLU Women's Rights Project and won. In that case, it was 14th Amendment, equal treatment under the law. In her next case in 1977, Califano v. Goldfarb was another case of a man being denied his wife's Social Security benefits. And in this case, she argued for the Fifth Amendment, again, that he was denied due process because it was an automatic refusal. She won both of those cases. So it's really important. The talk is entitled, "What is the legacy of the Notorious RBG?" And I think the legacy of the Notorious RBG, standing on the shoulders of particularly Pauli Murray, but also Dorothy Kenyon, is that we need to go to the Fifth and 14th Amendments, right? That rather than go through some of the lengthy procedures to pass civil rights legislation, that the Fifth and the 14th Amendments must be interpreted to guarantee equal treatment under the law and equal right to due process on the basis of sex, whether it's male or female. So those are the cases that Ginsburg argued before she became a member of the Supreme Court. And when Clinton nominated her, interestingly, he met with her for quite a long time to talk about her views about abortion rights. It was something that he was concerned about, and actually, a lot of abortion rights advocates were concerned about where she would stand on Roe v. Wade if a case came before her, because she was always concerned that Roe was decided on shaky ground, and that the ground it was decided on was about a woman's privacy to make a decision with her doctor. And she really believed, when she was questioned during her confirmation hearings in August of 1993, that this is a quote from her, "It is essential to woman's equality with man that she be the decision maker, that her choice be controlling. If you impose restraints that impede her choice, you are disadvantaging her on the basis of sex." And that argument, she believed, was the argument, again, turning to the Fifth and 14th Amendments, that should have been the basis for Roe. And I hope we'll talk about that a little bit in the Q&A. But when she made that clear to the Senate, any kind of resistance from abortion rights advocates faded away, and the woman who Bill Clinton called the Thurgood Marshall of women's rights because of her successes in arguing before the court before she ever sat on the court was approved, and she began her storied career on the court. Once again, on the court, she made clear her view on abortion rights. The decision whether or not to bear a child, she wrote, is central to a woman's life, to her well-being and her dignity. It is a decision she must make for herself. When government controls that decision for her, she is being treated as less than a fully adult human responsible for her own choices. Her critiques of Roe were quoted yesterday by Sam Alito, but I think those quotes are the ones that will need to be raised in the weeks and months and years to come, as women's right to a safe legal abortion is once again debated in this country. So a little discussion of some of her most notable cases. She was in the majority only for a brief time in in the late 90s. And one of her most notable cases was the 1996 United States versus Virginia, in which appellants, women sued VMI, the Virginia Military Institute, for its refusal to allow admission by women. In the end, the court ruled that the Virginia Military Institute did have to admit women, and out of respect for her, considerable experience in arguing women's rights cases, Ginsburg was assigned to write the opinion, and she wrote generalizations about the way women are, estimates of what is appropriate for most women, no longer justified denying opportunity to women whose talent and capacity place them outside the average description. And Steve Vladeck, who is a University of Texas School of Law professor, said that case, in many ways, more than any other, epitomized the justice's effort to establish true sex equality as a fundamental constitutional norm, and its effects are continuing to reverberate into the 21st century. And no one epitomized that decision more than Ruth Bader Ginsburg and her career before the court and her reasoning in that case. But for much of Ginsburg's time on the court, she was in the minority. And she became famous, as I noted a little bit earlier, for her scathing dissents and her lovely dissent collars. So I wanted to talk about a couple of those dissents. One dissent was in the case of Lilly Ledbetter, who had been an employee of Goodyear Tire, and who found out after 19 years of working for Goodyear Tire that she had been paid less than men doing the same jobs as she for the entire 19 years. Ledbetter sued, and in a lower federal court, she won close to $4 million in back pay, would equalize her pay to the men who did work, the same work that she did, but had been paid more for 19 years, but also damages. Goodyear appealed, and the case ultimately went to the Supreme Court. And Ginsburg was livid when an all-male 5-4 majority sided with Goodyear. She wrote in one of her most famous scathing dissents, "The court does not comprehend or is indifferent to the insidious way in which women can be victims of pay discrimination." She called on Congress to act, and indeed they did. Lilly Ledbetter, who was there when the decision, when Ginsburg read her dissent, said she got chills from Ginsburg's fierceness. Ledbetter was also there when Congress did pass the Lilly Ledbetter Fair Pay Act, and so was Ginsburg, and it was one of the first bills that Barack Obama signed into law. Other scathing dissents by Ginsburg, one that she was most furious about was not a sex discrimination case, but the Supreme Court's gutting of the 1965 Voting Rights Act in 2013 in the Shelby decision. And she wrote, "The sad irony of today's decision lies in the court's utter failure to grasp why the law has proven effective. Throwing out preclearance," and when she said preclearance, what the Voting Rights Act did is in states and counties, jurisdictions that had had a history of finding ways to exclude Black voters, it required that any changes in requirements for the right to vote be pre-cleared by the courts to make sure that they weren't racially discriminatory. In 2013, the Roberts Court decided that this wasn't really an issue anymore. We were all done, and we had racial equality, so we didn't need that, and the Voting Rights Act was gutted. She wrote, "Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." And, once again, she was absolutely prescient. In the 9 years since the Shelby decision, the right to vote has been restricted all across the country, and with voter ID requirements and closing polling places and throwing people off the rolls because there was maybe one letter wrong in their proof of address or one number wrong in their proof of address. All of these kinds of things were what has happened since the removal of the umbrella that Ginsburg aptly called the Voting Rights Act. So other notable dissents, and then I'm going to stop because we're almost at 40 minutes and I would love to have you talk with me. 2014 in the Hobby Lobby case. I don't know if most of you remember, but the Hobby Lobby case was a case in which a craft store chain that was owned by evangelical Christians resisted the requirement of the Affordable Care Act that they be required to pay for contraception, well, to include it in the coverage that they gave to their employees. And Ginsburg wrote, any decision to use contraception made by a woman covered under Hobby Lobby's or Conestoga's plan will not be propelled by the government. This isn't government overreach. It will be the woman's autonomous choice informed by the physician she consults. So once again, she came back to her fundamental argument that women cannot be considered first-class citizens. They cannot be considered to be covered by the 5th or 14th Amendments if they cannot make their own decisions about their own body, about contraceptives, and ultimately about abortion. There was another decision that she made about another dissent in a school case where young women brought a case to the Supreme Court about body searches and dress codes, both in being applied disproportionately to young women. And anybody who's had kids in the schools in the last number of years knows that this continues to be the case, that young women are their dress is constrained in terms of, spaghetti straps, skirt lengths, and all kinds of clothing that young men are usually not sent home for wearing. This was a case where young women were actually being frisked coming into a school to see if they had cell phones or other contraband that wasn't allowed in the school. And she gave, again, a scathing dissent about the men on the court not being able to possibly understand the humiliation of these young women coming into schools and being literally, as she said, manhandled. One of her last dissents came when the court in 2020, when the court struck down the Affordable Care Act's mandate that employers have to pay for contraception at all. And she argued, she wrote in with one of her best dissent colors and scathing, by the way, from a hospital bed, more on that in a moment. Today, for the first time, the court casts totally aside countervailing rights and interests in its zeal to secure religious rights to the nth degree. This court leaves women workers to fend for themselves, to seek contraceptive coverage from sources other than their employer's insurer. And absent another available source of funding, they must pay for contraceptive services out of their own pocket. She argued that the government had acknowledged that the rules would cause between 70,000 and 126,500 women of childbearing age to lose coverage for contraception. And she noted that the cost of an intrauterine device, when not covered by contraception, would take sizable chunks of most women's salaries, since they continued to be paid less than men across the board. She once again, I'm going to come back to Roe v. Wade, but I want to note that case, that last dissent, was made from her hospital bed. She followed all of the arguments from her hospital bed, where she was undergoing a gallbladder procedure and was in chemo for her longstanding pancreatic cancer. Again, the notorious RBG, almost superhuman. So a couple of final quotes on her view about Roe. She believed that Roe originally should have struck down the Texas law that Norma Jean McCorvey was arguing against. Norma Jean was Jane Roe. And she argued that the case was so extreme, the law was so extreme, that striking it down would have provided sturdy protection against more such extreme laws being passed in the future. In the last few weeks and months, something like 500 laws restricting abortion have been passed in anticipation of Roe v. Wade being overturned so they could go into effect. She also argued that this is a discrimination not just against women, but that overturning Roe is discrimination against poor people. Quote, if you have the sophistication and the money, you're going to have some place in the United States where your choice can be exercised in a safe manner. It would mean that it is poor women who have no choice. That makes no sense as policy. Interestingly, Ginsburg later admitted that she had a different case that she had hoped to bring before the Supreme Court to defend women's right to a safe legal abortion. It was a case, once again, in her interesting fashion, it was a case by another Air Force lieutenant by the name of Struck, who had been told when she became pregnant that she had to either have an abortion or leave the service. She was a religious Catholic. She didn't want to have an abortion. And she argued that it was her sex, because men would not face this same choice, that it was sex discrimination, a violation of her religious freedom, and a violation of her due process rights. That was the case that Ginsburg believed, had it been argued in front of the court and it was on the docket the same year as Roe, would have provided sturdier protection to the right to abortion. But it was dropped from the docket when the Roe case was argued and decided. So let me stop there. And I would love to take questions, open up for discussion. There's certainly a lot to talk about, and hope that answered some of your questions about the legacy of the notorious RBG.
Thank you, Annelise, and thank you in this week especially for invoking the memory of RBG. See, our first question tonight is from Betty, and other people are welcome to type in questions as well in the chat. Betty asks, given the current polarized political environment, what can we do to halt or slow the rollback of protections for groups that do not identify as cisgender white male?
This is a complex question. I mean, one of the fears that has been expressed since the Alito decision was leaked is that this decision impacts not only the right to safe legal abortion, but as the questioner implies, the rights of many other previously disfranchised groups. Those celebrating the decision today have already announced that their next plan is, first, abortion will be struck down in more states in the country than it will be legal in, for starters. And so, one question is, do we go back to the kinds of, for lack of a better term, underground railroads that women ran in the years before Roe to try to get young women to places where they could have safe legal abortions? In particular, between 1967 and 1973, such networks existed to get women to New York, which made abortion legal in 1967, and Roe was not decided until 73. So do we do that? Maybe, but also those celebrating the decision today said the next place they hope to go is overturning Obergefell and Windsor, which legalized same-sex marriage across the country. Nobody is yet talking about overturning Lawrence v. Texas, the 2003 decision that banned sodomy laws and laws criminalizing non-consensual sex. but certainly that is something that might well happen. And then, of course, there's the whole spate of laws criminalizing the protection of trans children. And, we're already seeing what's happening in Texas to families defending their children. So I think it's a multifaceted front. My students were in panic today. They were asking me questions all day about what we can do. Vermont, the first thing we can do, I suppose, is pass that constitutional amendment in the state of Vermont that protects the right to abortion as a human right. California has announced today, the governor announced that he's going to try to get a similar amendment in California and do everything he can to make California a safe haven. I'd love to see Vermont a safe haven. But I myself live in a part of the state where everybody who would get an abortion would be doing it at Dartmouth Hitchcock, which is in New Hampshire, where the right is much more fragile. So I think that it's going to have to be argued. I think many things are going to have to happen. I think, first of all, the midterm election, abortion has now become the issue of the election. If the Democratic majorities are expanded, then there will be a chance of codifying Roe under the law. Because we'll have enough people to overturn the filibuster. If not, then that will not be the case. And all across the country, as soon as Roe is overturned, these trigger laws that are now already on the books in 13 states will go into effect. So another 13 states will have outlawed the right to abortion. So I think there will be, electoral campaigning has to take place, litigation has to take place, but the litigation can no longer go to the Supreme Court, I'm afraid. And so the question is, what will happen in lower courts? I think it will also be another reason it'd be really important to maintain the Senate majority is to try to get more justices on the federal bench who are sympathetic to the view that Ginsburg articulated, that the 5th and 14th Amendments have to be protected. If the 14th Amendment is thrown out, in effect in the way that Alito did, or interpreted in the way that Alito did, then civil rights in general, as the questioner suggested, are really in question for many groups of Americans. And it also includes surveillance. There are many issues that are raised by this decision. And, I, for one, sure as hell wish RBG was still around to put the force of her intellect into this struggle. But, it's going to be a multi-generational struggle. Young people are terrified. My young women students today, all day long, were expressing their fear and questioning what has to be done. And I think I'd love to see, some intergenerational conversations between the generation of women, my generation and older, who are the people who won us reproductive rights in the 60s and 70s, and these young people who are now trying to figure out what to do.
Yeah, maybe climbing down off those shoulders folks are standing on and talking face to face.
Absolutely. Other thoughts, questions, anybody out there?
I'll ask a question while we've got a moment. I was wondering about the importance of dissent, when the Supreme Court has taken such a strong shift. What is the value of that voice of dissent?
I think the value of the voice of dissent has been shown since Ginsburg's death by Sonia Sotomayor, who has issued similarly scathing and brilliant dissents. Because I think that there's a feeling that the Supreme Court of the land are the juridical experts. They are the moral arbiters. And, that question was certainly opened up during the Brett Kavanaugh hearings when, angry women flooded Washington and asked whether someone, who had been charged with sexual assault multiple times would be confirmed to the court. And so I think that, in that moment, there was a really powerful statement by a young woman who was arrested, who wrote a statement in a piece, an op-ed in USA Today after that, and who said, she pointed out that I think Ben Sass, the Republican senator from Nebraska, had commented on the hysteria of women who were flooding Washington to protest the Kavanaugh nomination, and her op-ed was called "Women's Hysteria is what we need right now to save America." So I think once again, there's going to have to be a lot of levels on which these are fought. But Sonia Sotomayor's dissents have, I think, made clear that there are other kinds of legal reasoning that are possible, as Ginsburg did all this time. And I think those dissents invite litigation from the lower courts. And I think that will be really important. I don't know what will happen. I don't know if the court will be expanded. I think that is, certainly a possibility. But Sotomayor talked about the stench of politics in one of her dissents, the stench of politics having started to delegitimize the court well before all the hand wringing today about, this leak, and how it had finally politicized and delegitimized the court. So I think the power of beautifully written dissents is really important for younger lawyers, for younger legal scholars, and for people who might want to bring cases as appellants themselves.
I'll ask a question. It's related to what you've already touched on, but how is it that for 50 years since Roe v. Wade, the due process clause of the 14th Amendment was interpreted to encompass a right to privacy, and then suddenly it's decided, well, no, it was never there, and it's not going to be there any longer? If that's what Samuel Alito is saying, is that just new people decide completely differently? They don't see, they're strict constructionists, or they're not constructionists. Thinking back to Justice, what's his name, Scalia, I don't understand how this can so completely be thrown out when it's been a precedent for 50 years, or an assumed part of the 14th Amendment.
I think the real issue, and Jeff Sessions said it when he was Attorney General, that the far right has, and Alito is definitely far right, is with the 14th Amendment itself. And in Jeff Sessions, when he was Attorney General, and his arguments against birthright citizenship, which is unfathomable, right? I mean, all kinds of these things are being argued now that are unfathomable, courtesy of the Federalist Society. But also Jefferson Beauregard Sessions is part of a number of people who believe that the 14th Amendment was the beginning of the end, right? Because it was an attack on states' rights. And I don't think it's an accident that Alito talked about states' rights and held up the banner of states' rights in the decision, because the 14th Amendment, its most powerful guarantee is equal treatment under the law, no matter where you are born in the United States, right? And so if you're interested in diminishing the power of the 14th Amendment, I think that's the undertone of Alito's decision yesterday, that the 14th Amendment itself has to be constrained so that people like an RBG or a Sonia Sotomayor or a Thurgood Marshall do not try to turn to the 14th Amendment to uphold due process and equal treatment under the law, because obviously, as Ginsburg said, any decision that takes away a woman's right to decide whether or not she is going to carry a child in her body and bear a child, which I'll tell you from my own experience, giving birth is still a risky proposition, that a woman has no right to that decision, makes her absolutely a second-class citizen. And Alito said that this decision was the Brown v. Board of the unborn, and several legal scholars today said, it's nobody's Brown v. Board, but it is in fact the Plessy v. Ferguson for women, right? And Plessy v. Ferguson is the decision that separate was okay as long as it was equal, right? Brown said separate is inherently unequal. So I think Ginsburg again and again hewed to the 14th, and so I think your question is really important, and I anticipate seeing a number of cases that attempt to interpret the 14th Amendment in exactly that way to stop people from using it to defend civil rights. Oh, wait, there's a Q&A over in the Q&A. Okay, Sarah, have there been many cases of settled law being overturned in history. There have been some, certainly, but the question that was raised by a number of people in the Senate today was that all of these justices who voted for this, at least draft, had called Roe settled law. So, were they lying, or were they, as the questioner suggests, were they, not saying that they wouldn't overturn settled law? There have been, and in fact, Alito did cite Brown v. Board overturning Plessy, which had stood for 60 years at that point. No, 50 years. It's a similar time frame. So yes, occasionally settled law is overturned when there is a compelling reason, when there is really bad reasoning. I think, the bigger question is, what you do with a society in which the majority of Americans now do not remember a time when women did not have the right to a safe legal abortion. That's not to say that the right hasn't been steadily whittled away since Roe was decided. Even before this, 75% of the counties in the country, you could not get an abortion. So in most of the country, even before this, women could not get an abortion. It was slowly whittled away by all of these laws, especially since the 2010 midterm elections, when a new kind of conservative Republican took over state legislatures all across the country. We have that's the one. Okay. So yes, that is done. Oh, here's another one. Are there potential legal consequences for the 3 Trump appointed justices who said in their Senate confirmation hearings that Roe was settled law? Interesting question. And I don't know the answer to that question. I'd love to see what comes of this. More to the point, at least one of those justices, it seems to me and many other people, has absolutely invited impeachment proceedings, and that is Clarence Thomas, for refusing to recuse himself in investigations of the January 6th assault on the Capitol, when there was all kinds of evidence that his wife was a funder of it and that she was a planner of it. So that is actually a clear and egregious violation of judges' ethical norms. But again, the Supreme Court has operated as a kind of star chamber free of a lot of the ethical rules that constrain judges in other kinds of federal courts. And so I think a question that has to come out of this is, whether in fact it's time to change the way the Supreme Court is treated, and, to not have the court justices able to serve maybe for a lifetime. One suggestion that came up with the commission to investigate the court is that perhaps the entire federal appeals court bench, which I think is 176 justices, becomes a pool to rotate on and off the court for limited terms. There are a lot of interesting possibilities, but I do think there is a chance that perhaps they will be called for perjury. I don't know. Be interesting to see. I think there is one more question.
Yeah, one more question from Jacqueline. I think she's asking if RBG had retired early, if you think Obama could have appointed a liberal justice to the Supreme Court.
Well, she clearly would have had to have retired before Scalia died, because Mitch McConnell blocked Obama appointing anyone. So there are a lot of complicated questions here, including the man who broke the Senate, Mitch McConnell. So I think, could he have done it? Maybe. RBG's taken a lot of flack for this decision. Oh, Deb Kramer, thank you. Yeah, I think it's possible. We don't know. And but I think we got a lot of work to do beyond blaming RBG for staying on the court and to the end, because I'm not entirely sure that once the Republicans took control of the Senate in 2010 that anybody would have been confirmed.
I think a follow-up question from Judy was, does Congress have the authority to call justices to hearings regarding their statement of settled law versus their willingness to overturn it?
Congress has the authority to subpoena anyone they want. But as we saw today, when they subpoenaed 3 sitting Congress people who were involved in the January 6th assault, and they simply refused to honor the subpoena. So the question is, will Congress arrest their colleagues or anybody else who refuses a subpoena? They have the right to do it. They won't do it. Certainly, out of respect, I've not seen anything ever like a Supreme Court justice being subpoenaed by Congress. But we're in terra incognita these days. We're operating in a really new time. Thank you, Betty, for your thank you. Yeah, this was great.